Hello, and you're very welcome to episode 12 of The Fifth Court, a podcast on legal affairs presented by myself, Peter Leonard, barrister.
Myself, Mark Tottenham, barrister and editor of Decisis.ie.
Mark, as always, good to see you. And let's reflect on last week's show. We had a wonderful discussion with solicitor Flor McCarthy, the co-founder of Solicitors Growth, a network for solicitors providing CPD and support services. Wow, is that man innovative?
Very.
Great response. The solicitors loved that, didn't they?
Yeah, definitely.
They loved that. They loved that. Well, today we're still on campus in University College Cork, and we're moving into the world of criminal law with one of the country's best-known defence solicitors, Frank Buttimer. He's probably best known, I suppose, for his relationship with Ian Bailey, representing Ian Bailey over the years. But there's a lot more strings to Frank's bow, I think, and we're going to discuss those. It's a great interview, folks. Stay with it. But first, we're going to discuss 3 cases which have been identified from the Decisis website by your good self, Mark. The first tonight, we're going to start with the bodice-ripping topic of rateable valuations. Maybe I'm being a little bit unfair because this is quite an interesting case and it concerns the valuation of land. And at what point do you value land? In this case, the land was kind of a field, I presume. And then had been a field, and then it was a field with a wind farm on it.
Exactly.
So at what point do you value this piece of land?
Yeah. So what happened here was the Commissioner for Evaluation is the person or the body responsible for fixing the rateable valuation. And they fixed the in this case, as you said, it was a wind farm. The valuation date was October 2015, where there was I don't know if the wind farm was being built, but certainly it wasn't operational because it wasn't operational until September 2017. But the Commissioner for Valuation made a decision to value it based on its 2017 valuation rather than at the time of the valuation date, because the valuation didn't take place until 2017. And this was challenged by the owners of the wind farm, and it ended up before Mr. Justice Simons in the High Court.
Yes.
And Mr. Justice Simons looked at this and said, no, you're supposed to value as at the valuation date. And he made specific reference to the fact that there was provision in the legislation to revise a valuation if there was an event that changed the valuation of the land.
So the valuation date in this case was when it was just a humble field.
It was a mere humble field with no wind farm, and 2 years later, obviously, it was extremely valuable.
So slightly worth a little bit more, I would have thought?
Just a bit more, I would imagine, yes.
Okay. And that is the case, I should say, of Quilter Cho versus the Commissioners for Valuation. And again, as you said, a decision of Mr. Justice Simons. Okay, I think we can only squeeze in one case, Mark, because the Frank Buttimer interview runs a little bit and it's well worth listening to, folks. But this is a case where it's kind of about practice and procedure. Is that a fair enough comment for me?
Yeah.
It's a decision of Miss Justice Stack, and she had a lot of work to do in this decision, a lot of things to consider. The backstory concerns a family home in which the borrower or mortgagor had defaulted on his loan. The property had been repossessed, but the plaintiff decided he was going to attempt to take back possession of the premises by force, and he was going to use an angle grinder, rev it up and seek to obtain entry through a steel door. He was going to chop it down with the angle grinder. And however, he notified the guards, maybe he had in advance that this is what he intended to do. They turned up, they arrested him. He says a little bit too much force was used. He ended up in hospital as a result, all of that sort of stuff. Anyway, it eventually went to court, but he didn't just sue the guards. He sued a plethora of parties. So can you take us through it?
Well, the particular issue here that he was objecting to was the fact that he had mortgaged the property with one financial institution, and that loan, as is quite common, got sold on to another financial institution. And an order was made by the county registrar giving possession of the property. But by the time, that application was made in the name of the first financial institution, and by the time that order was made, the second financial institution owned the loan. So the point was, in fact, that the order had been made in the name of the wrong body, and the borrower was clearly alive to this because this was the reason why he went back into the property, forcibly re-entered. He was arrested by the guards. He says that excessive force was used such that he ended up in hospital. And as you said, he then sued everybody involved. He sued the county registrar who made the order. He sued the guards. He sued 2 other guards who had prosecuted him unsuccessfully in the district court. He sued both financial institutions.
So Miss Justice Stack was called upon to decide whether these proceedings could continue.
Exactly. An application
and she said certain ones couldn't.
Yeah.
But certain ones could. Very difficult. Well, you're doing a brilliant job explaining this, Mark.
Well, so an application was made to dismiss the entire case, and she went through each one, and she said, case against county registrar can't succeed because he had a right of appeal and he's out of time to judicially review it. The action against the guards could proceed on the basis that it was personal injuries action, and this needs to be determined. The action against the prosecuting guards couldn't be because there was no evidence of malice behind the decision to prosecute. And then the action against the body, the financial institution that went into possession, could proceed, even though it was likely that it wouldn't succeed, because it was at least a stateable case, because they went in on foot of an order that they shouldn't have gone, that wasn't made in their name.
Wow. Okay. Can you mention the one in the middle again? Sorry about that. Brilliantly explained. I don't know how you take in that detail. It's fantastic, Mark. Okay, back shortly with solicitor Frank Buttimer.
Silence in the Fifth Court.
It is my great pleasure to welcome to the studio Frank Buttimer, one of our best-known criminal solicitors. I suppose, Frank, you're nationwide, but you're based here in Cork, and we're delighted that you came in to talk to us. And you had a busy day today. I know you were rushing from court, were you?
I was, Peter.
District, circuit?
District, primarily, and a few other operations as well. We had some significant matters in Tralee today as well, where people were unfortunately charged with rather serious offences down there. So I had to organise that as well with other staff. We have a relatively busy operation, and it does keep us going.
And you do more than crime. In faurness, I'm pigeonholing you a little bit. You do a bit more than crime as well, don't you, Frank?
I do civil litigation. I do,
all that sort of stuff. We love the crime. We're going to ask you a lot about that.
I do a lot of different things. Yeah.
Okay, so before we get into some of your well-known cases and to talk about kind of crime and how it's dealt with in Cork and nationwide, can we go back to where it all began? Where is Frank Buttimer from? I know you're a Cork man, and how did you get into this legal game?
I'm from about 500 yards up the road in Magazine Road, a little place called Kilcray Park, which is about literally, 300 or 400 yards from the main gates of UCC. And I was born and reared up there, not far from here, as I say. My mum and dad were teachers, so I went to my mother's primary school, Glasheen Boys National, and I went to my father's secondary school where he was teaching. He dragged me across the river up to the north side, which sort of toughened me up, and I did my secondary education up there. And when I was going through the North Monastery, I heard that there was this career called law, and I had no idea what it was, but it sounded vaguely interesting. All of my other family, my mum and dad and all my brothers and sisters were actually teachers, as it eventually transpired.
So you were going to go rogue, and it was nothing to do with Perry Mason.
I was black sheeping, and so my father was frowning upon this concept, but I said, look, let's go for it. So I came to UCC in 1974, this very building, and I studied for the BCL. Well, I use that term loosely. I attended UCC, where I had a really, really great 3 years, made some great lifelong friends, graduated in 1977. But during those times, you could become an apprentice while you were still in college. So I got through the whole system. From the age of 17, I did it all in 4.5 years. So I was qualified as a solicitor at the very, very young and inexperienced age of 21 and a half, or give or take.
And who did you train with? What firm did you train with?
I trained with a firm called O'Flynn Exums and Partners.
Here in Cork City?
Yeah, they did their best to get rid of me, but I hung in there, and I escaped with my reputation vaguely intact. Mr. Faulkner O'Driscoll, who's still practicing, and God bless him, was my master, as they used to call it back then. He and I would have had different views about legal practice. He was a very hard-working guy, and I got to tell you, I was not. So I graduated and finished my what do you call that thing, solicitor's course in 1981. And from Dublin, I was up in Dublin in the old, not Blackhall Place, it was preceding Blackhall Place. There was a great spot called Earlsford Terrace, actually, where the Law Society used to have its educational activities. So you did about a year and a half or so up in Dublin, which was really good. I lived in an accommodation, shall we call it, in Rathgar, and really enjoyed that as well. And then I promptly decided that I
sounded like a real Dublin solicitor there.
Rathgar. And I then said, I don't want to give my life to this.
So when did the nameplate, when did the brass plate with Frank Buttimer and Associates, or whatever you call yourself, when did that happen? When did you go out on your own?
Well, I opened my own business in 1986. 1986. I had been an
At the
assistant.
tender age of what, 26, 27?
27-ish, something like that.
Yeah, okay. And why did you go out on your own at that stage?
I always wanted to. I never wanted to be, shall we say, anything other than, to the best that I could be now, sort of in charge of my own operation. I was in partnership to some extent with a guy with whom I had been working as like an employee. He had various operations around Ireland, Munster particularly, and I wanted to. I'm very attached to my home city. I had lived in California for a couple of years, but I wanted to be my own boss, as it were. So I just took a flyer and opened a business, and it's been on the go since.
Okay, very good. And did you start doing crime at that stage? Now, I know you do civil litigation, as you pointed out, but was crime the thing that attracted you? Was that what you started doing first?
Yeah, it was. What I did was, when I began to work, I took 2 years out after I qualified, started to work in 81, and the nature of the operation that I was working in was like a legal office which did a lot of litigation, and litigation involved attending the district court, and I became the district court attendee for the office, just by the way it worked in the office, and I began to like it and, did it. It was a country practice, actually. And it was like from San Francisco to Kanturk, County Cork, which is a bit of a culture shock. But I began to do the district courts locally and maybe a bit further than locally eventually. And then came to Cork in 86, to my own hometown, and then continued to do court cases. And that sort of stuff doesn't happen. You don't become a kind of a good operator immediately. You become a good operator, if one wants to call oneself that, by acquiring experience, one's own activity, and then observational activity, attending your own courts and maybe going to the higher courts for barristers and, that kind of work.
And when you started, let's say, in the mid-80s or whatever, like what sort of crime were you dealing with? Is it very different to what you're dealing with today?
It's 100% totally different across the boards. In terms of the nature of criminal offending, in terms of the nature of criminal practice, in terms of volume, in terms of the nature of the people who you represent. I mean, it's so different that people who are now coming into it or who have been in it even for the last 10 or 15 years would have no idea of what it was like back then and the way in which you would have to do your work back then, as opposed to the different types of activities in which one presently engages. It's chalk and cheese.
Can you give us some examples there? I mean, in terms of the types of offences you're dealing with.
Nowadays, the most prevalent offending in Ireland would be, besides road traffic, which has been prevalent enough anyway, you're talking presently public order. The Public Order Act only came into being about less than 30 years ago. There was no Public Order Act up to then. That's the most prosecuted crime presently. Misuse of drugs, theft. They'd be the most common crime prosecutions that I would come across now. Whereas back then, you'd have much less of that, much less crime. You might have some thefts to some degree. You'd rarely get drug prosecutions because we didn't have a drug culture, certainly in Cork and probably in Dublin, kicked off maybe the late 70s, 80s. Cork, not until the 90s, 2000s. So you'd like to see a drug case back in the 1980s was as a rare bird, even possession of cannabis. And then you'd have, first of all, you'd have far fewer cases. The other actual difference, interestingly, from a practitioner's point of view is back then you had to be a better advocate and you had to be able to think on your feet better because you were going into the district court without the benefit of having disclosure of what the state's evidence might be. And that didn't change until there was litigation called the Gary Doyle case, which allowed or directed the police to provide defence material to the solicitor who would now be representing the accused. In my day, when I started out, and what may have made me a decent operator in terms of advocacy, was I had to think on my feet what the police guy might be about to say, match that with my instructions, and then have to cross-examine on the hoof, and then still make sure that I wasn't going to ask the wrong question. Because we all know, guys, rule number one in advocacy is don't ask the question to which you don't know the answer. So it really would prepare you for other things down the line and things that you would look out for now. But back then there was an element of intuition and an element of, kind of cop on.
Yeah.
What's the way?
Can I ask you just as a defence solicitor, and you've always been defence, Frank, pretty much.
Yeah.
You've never worked for the state in terms of prosecution and stuff like that. I mean, to the public at large, they often wonder, say, how can you represent these guys? How do you, how does your conscience allow you to represent people like that? Will you give us a few insights into the thinking of defence solicitors? You're just representing, isn't that it?
Yeah, well, I mean, look, first of all, we have a constitutional system where people are entitled to a defence. I mean, if you look at the overwhelming power of the state against individual, that's a very important principle that democracy suggests that we should have, a system that is fair. The important thing, like from a solicitor's point of view or a legal practitioner, you cannot be judgmental. I mean, if I become a judge of my own client as to what the client may or may not have done, I'm in the wrong business. If I want to become a judge, I'll become a judge. I become a defender. And what a defender's position is assessment of evidence. Our system is evidence-based. It's not a system of morals and so on and so forth. Those matters feed into judgments that may be imposed by judges when people are guilty. The way I approach, in cases of any given kind, actually, be they extremely grave, medium, low level, I assess the evidence. I may have to do that at the very, very beginning of a consultation, where I might have to go into a Garda station and advise somebody about rights to remain silent and so on, and whether it's beneficial to make a statement or not. So therefore, I try to do an early assessment, almost like a prediction of what the evidence might be. The other point in time at which you may then consider the evidence would be when a case has been brought into court, you're presented with, statements or books of evidence, and you assess it then. And in a very, very large number of cases, I never actually ask a client what the client's actual story is. Sometimes never, and sometimes only at a quite advanced stage in the process, where I'm saying to the client, look, here's the level of the evidence. It looks like X, Y, and Z from the point of view of the prosecution case. You have a case to answer. And if you have a case to answer, then tell me your answer. If you don't have a case to answer, you do have a right to remain silent, but the evidence suggests you're going to be found guilty unless you have an answer. That's the professional assessment that one has to do.
Yeah, okay.
It's an assessment of the strength of evidence.
Brilliantly explained, Frank. Okay, so we know we know you have a number of high-profile clients. Can I ask you, when did you get, let's say, a high-profile client that the paper started focusing on, and suddenly, it was slightly different because you had to deal with, let's say, media interest as well as just representing your client?
The first case that became very public for me was not a criminal case. It was a tragedy involving a drowning in the 1980s, late 80s, in a place called Ballycotton, where a number of men who were in the service of the state as fisheries protection officers drowned in tragic circumstances and unexplained circumstances in many ways to this day, and where I represented the families of two of the four men who were fisheries protection officers and whose deaths became the subject of inter alia, a public inquiry, and it was a matter of some significant prominence at that time. And I wasn't long in my own business at the time, and it did attract a lot of sort of national, maybe to some extent international attention, because it was most unusual. There were question marks as to whether they were dragged down by submarine things and stuff like that. So that was one that I remember having to go into court to do inquests and stuff, and you'd be the focus of media attention, and I had to make some commentary on the radio, and I, realised, that's a pretty serious piece of work. And it wasn't just from the point of view of the clients, the families of the late gentleman, but it was the public interest. And I suppose I began to learn to some extent, not, what I began to learn communication with the media as a separate sort of tool of the trade, the need to be communicative. What does the public need to know about a matter of public interest, as opposed to what needs to be, kept private, kept confidential, privileged, and so on. That was the first one I remember.
Okay, and are you part PR man then?
Yes, without a shadow.
Okay, and you have no embarrassment saying that
I
at
don't
all?
Indeed, no. And but I hope my conduct in the public domain has been proper and appropriate. That's not PR in the sense of it being, an abuse of a kind of a facility or portraying something in a way that isn't true, or doing a kind of a snow job on it. It's actually a need to communicate, because there is a legitimate need on the part of the public to know sometimes what a defence position may be. And I mean, I've had it in at least 2 or 3 very, very big cases, which became enormous cases.
Yes.
I mean, I did a case in Middleton. It was a desperately tragic case in 2005 when a young man called Wayne O'Donoghue was involved in the initial disappearance and subsequent, cover-up, as it was perceived, and rightly so in many ways, of an event which was like an international case. It was all in Sky News and BBC and all this business. And it was the most tragic, amazing, case. It devastated the family of the young lad who was killed, Robert Houlihan. It was devastating for his mother, his father, his family, for the community. It then became devastating for Wayne O'Donoghue. I'm sure you'd know the case.
Yes,
Wayne was prosecuted for murder. And that case was of such enormous public interest that it was necessary to be hugely conscious of what the media portrayal of the case would be like. And my view about the manner in which the media needed to be dealt with was, quite simply, that when the event occurred, when it was detected, when Wayne came forward as the offender and then inevitably was going to be prosecuted, I knew, and I believe rightly so, that there was going to be a jury who was going to hear the case 12 or 18 or so months' time down the line, and who needed information, in fact, to counterbalance the portrayal that was going on, whether subtle or intentional or otherwise, in other quarters. So it was the first case that I really realised something has got to be said, but very carefully, not to influence in any improper fashion or anything a jury, but just so that the jury might be aware that what they might be getting fed, which they were, in other quarters of the media, needed a counterbalance.
So you effectively were looking at it as trial by media, and you were defending your client in the media.
Yes.
And because, I mean, there's often the perception when you hear sort of solicitors going onto the media to talk about their cases that they're assisting and promoting themselves. But you very much felt that this was to your client's benefit.
It wasn't a question of benefit. It was a question of fairness. And I think it was the first case that I can recall where there was such an extraordinary level of public attention, and there was potential, I'm not saying manipulation in the pejorative sense, but manipulation in a sense that might have been unintentional, but it was certainly influential potentially, that it was necessary to take a grip on the defence side. And And
could that not be dealt with by, for example, sort of writing to the individual news outlets and saying,
Never.
You have got this wrong, you have misportrayed this, and I will be reporting it to the judge or making a case for contempt? You felt it was necessary to actually put the case forward yourself?
Yes, absolutely. And it wasn't that I was discussing evidential matters, because I wouldn't have even had evidence at a certain period of time, but it was the way, it was really the way in which I knew that a jury, whom we never could have known who they were going to be, because it was going to be 12 months down the line. But the minute Wayne, for example, was arrested and brought before the court, I remember it very well, down in Middleton District Court of a very cold night in January, and there must have been 40 or 50 media personnel there. And I remember telling him how to walk, how to look, what not to say, what way to turn, what to do. It wasn't manipulative. It was just, remember, there are people who are genuine, ordinary, decent people who are going to be looking at you. They're going to be watching what's going on. When it does come to evidence, jurors are rightly warned by judges, you are only to consider the evidence. And I hope that juries accept that as a direction or a charge from the court, and I believe they do. But there will always be the danger or the risk that perception may influence. Yep. And I've always thought that. And in the modern age, with modern media and modern, communications and internets and so on, it isn't that you're doing something at all improper. It's just that you're doing something that is necessary to ensure that a media perception is balanced.
Okay. Well, you talked about the Wayne O'Donoghue trial, which was absolutely huge. But can we talk about the Ian Bailey case? I mean, if Wayne was a huge story, this was completely off the charts and has been for the past, 20 years?
It's been off the charts all right.
Can I ask you first how you got involved in defending
Certainly.
Mr. Bailey?
Ian Bailey was the focus of attention in, I guess, late 1996. I was not his solicitor. I did not advise him when he was arrested. The late Con Murphy, subsequently Judge Con, a friend of mine, was his advisor. And what happened was, I remember that I had done another high-profile sort of case in Cork, which ended a short time before the Ian Bailey case. And I think he must have heard about me or something, or somebody might have mentioned me. So this guy, Ian Bailey, rambles into my office in or about, I'd say, March 1997. I knew who he was. He was not my client. He was Con's client. And he came into the office and I said, oh, there's that guy, Ian Bailey, and so on. And he was connected with that case, about which I hadn't much knowledge, actually, because I have enough to be doing. I don't get involved in other people's cases, believe me. I don't read cases in the paper. I have enough to be doing. But I knew about this because it was a common knowledge kind of thing. In comes your man, sits down in the office, and I'm saying, oh, there's your man, Bailey. And literally, I started chatting to him. I knew absolutely intuitively that he had nothing to do with that crime from the minute I met him, because of what I spoke to him about, what he said to me, my knowledge at that time, even then, of criminal law and human nature and whatever you're having yourself. And his purpose in visiting was effectively, no disrespect to my good friend Con, it was, if I ever happen to be prosecuted, would you consider acting for me? And I said, I'm not sure if you ever will be. We'll cross that bridge if we ever have to come to it.
So it was a case of having the chat before you came on board.
Yeah. And of course, he was never prosecuted anyway. And Con did the legal business that was required, to include Ian Bailey being arrested. A year later, Con went to the station, advised. And again, he wasn't prosecuted. And then Con ran the civil actions against some number of newspapers. And I was watching it on the side, really. And then what happened is Con retired and became a judge in 2003. At that time, there was a need for Mr. Bailey to appeal certain cases against some newspapers, and he asked me if I would take it on.
And that happened at the Circuit Court here in Cork,
Indeed,
isn't that right?
And then we appealed that to the High Court on circuit is the process. And we had some success, even though people don't necessarily appreciate that because the case is so convoluted. But what then happened is, while that case was pending, and Ian Bailey's case was always in the media. I mean, it was just non-stop and ongoing, even before I got stuck in it. But then what happened is, when I began to run the appeals, I got this, I was doing certain things and trying to piece things together. By the way, back in those days, I used to do a huge amount of, I used to go door to door, knocking, looking for witnesses, stuff that people wouldn't even dream of doing now in other cases, and I used to do my own thing. Anyway, I got this phone call out of the blue from none other than Marie Farrell. And a funny story, I'm sitting in the office.
This is the woman at the bridge.
She's the star witness. So I'm in my office someday, 2005. I was aware of her and so on from other reasons, but I actually had forgotten her name even. And I'm in the office and I get a phone call. My receptionist says, there's Marie Farrell on the line. And I'm saying, well, who's she? Honest to goodness. And she said, she's a witness in the Bailey case. And I said, I should put her on. So she comes on for about 30 seconds. And I just like, you're the witness. And I said, I can't talk to you. And she said, but I need to talk to you. And I said, but I can't talk to you. I thought she was like setting me up or something. And she said, I would like to tell you the truth. And that was the first enormous crack that was, tangible in the case. And I met her 3 times very carefully and got her legal advice of her own, because I figured she could get prosecuted for perjury and all this. And she told me the truth of her dealings with the police. And of course, what happened about that was beyond sensational, but I had to, manage it very carefully and legally and properly. And there was a guard inquiry into that, and inquiry after inquiry. Then there was litigation which we took against the state, and it rolled on. And then there was the beyond sensational extradition, contest that we had to raise against the state for extraditing.
Can I just scroll back a little bit, Frank? I'm very curious about this. I mean, You seem to have developed a relationship with Ian Bailey before you were his representative. Was that for a period of years?
No, he used occasionally to contact me. I was not his lawyer.
Okay.
The tragic incident happened in December 96. I did not begin formally to represent him
till 2003.
Early into 04.
And did you break your own rules? I mean, your opening statement was there. After the brief conversation we had, I knew he had absolutely nothing to do with it. That's what you just said.
That's right.
Is that kind of breaking your rules, where you don't kind of get into the issue with your clients, or
he wasn't my client?
He wasn't your client. Okay.
He was a person who said, "If I need you, could I become your client?" And he had his own lawyer, and I said, "Of course." It was almost like, if I ever need the particular expertise that you have, as it seemed to him, or as it may well be, could I avail of it? And I said, if you ever need it, absolutely. You have Con, who's a very able solicitor.
Yes, absolutely. We all remember him as a circuit court judge, wonderful judge.
Absolutely. And I said, look, and he did, of course, remain with Con, and rightly so, but it wasn't, not at all, it was merely a future event that might occur, which didn't happen.
Yes.
But then
can I say, so when you came into the case, it was effectively 7 years old, 1996 to 2003, or maybe 6 years,
correct,
or whatever. I mean, obviously it had been alive for a long time. Did you have any notion at that stage that we'd be still talking about it today? I mean, obviously high-profile cases you'll always talk about, but that it was still ongoing, that there was still issues in the background, extradition warrants, all that sort of stuff that's still alive today?
Never. I never, ever thought that it could be or become what it became. I never thought that you could punch such a large hole in the state's argument by a person switching completely from being the key witness for the state to being the woman who said that story was rubbish. It was a concoction to suit an agenda. I could never have envisaged the extradition events, but I began to get rinklings of the extradition in 2008, which is a long time ago now, when I began to get communications to the effect that the state were being required to provide cooperation to the French authorities. So you're saying, by the way, in 2008, the state had clearly decided there was a key event occurred. I knew by 2008 that he was not going to be prosecuted because of the fruits of the Marie Farrell, inquiry, etc. And in 2008, I realised that the French had been waiting in the long grass, and that they were now going to start off the, if you guys don't do it, we're going to do it routine. And they engaged with the state, mutual assistance provisions, 2008 to 2010. And of all my years in practice, if I can say it, after 42 years now, one of the most memorable events in my life was the night I got the call, 2010 April, to say your client is being arrested to be removed to France. Dark of night.
Okay.
I'm in Cork at home. Bailey is lifted. Dark of night, down in Skull, and I knew he was going to get brought to Bandon Station. I drove to Bandon, parked my car. There was media there already because of the usual tip-off. I parked my car at a place past Bandon Station, 1:30 in the morning, and next thing, in the dark of night, 2 cars whiz past, police cars, 7 or 8 police officers, Irish, with Bailey in the back of the car, the long arm of a foreign nation reaching into our country to remove one of our people to their country, and we're doing their bidding. Now, this is the 3rd time he was arrested, and this time to be thrown out of the country. And I just thought, this is frightening stuff. It frightened me.
It is extraordinary. I mean, for people who don't know the details, I mean, he was arrested pursuant on a European arrest warrant.
Correct.
And basically, in circumstances where, following an extensive Garda inquiry, the Director of Public Prosecutions in Ireland determined that they weren't in a position to prosecute him. Mm-hmm. And yet, the state below court level was prepared to cooperate in order that he be prosecuted in France, effectively to a different standard of proof, to put it
correct.
Mildly.
You're quite right.
In circumstances where our own authorities felt he couldn't, there was no prospect of securing a guilty conviction here.
Correct.
which I think you're right. I mean, it's certainly something that should concern everybody.
Sure.
And it's curious because the recent Islamic the trials that have been reported on recently in France. I mean, the standard of proof is so extraordinary that it seems to involve. It seems to involve kind of effectively kind of victim impact statements before a jury, before a determination of guilt. I mean, it's a very different standard.
It's frightening. The whole thing was frightening.
So how did you fight that extradition?
Yeah, I'll tell you exactly if you've got about 2 years. What I did was, just on that night, I remember going to the police station in Bandon right away because that's where he was brought, and saying, look, I'm here, I'll take care of you, I'll do the best I can for you. He was distraught. I was very well received by the then police because they were just doing somebody's bidding. I had to go to Dublin on the Saturday because imagine they brought him to court on Saturday. I got a speeding ticket on the way because I was trying to get up there so fast. I think we sorted that one out subsequently. And what I had to do was really I'd never done an extradition case. I just had to figure it out. I had a fantastic team of barristers and we had to get a French lawyer. We got that through an organisation called Fair Trials International, which is like an Amnesty International type organisation. They got me in touch with a French lawyer called Dominique Tricot so that we might acquire a lot of French legal knowledge. So we had to do a lot of that. And then we had to put up our opposition, and we did that. There are lots of deadlines on the extraditions, and they're very strict, and because it's meant to work in a simplistic fashion. Big long production there, up to the High Court, fought the case, and to my beyond astonishment, the learned judge decided that we were wrong and that he could be thrown out. So
that he could be extradited.
He was ordered to be
even
extradited.
though the DPP wasn't going to prosecute.
The DPP had nothing to do with extradition. That's the whole point. The learned High Court judge decided that he could be thrown out and ordered him to be removed. And the other thing that was frightening about it is that judge had it within his gift to allow an appeal. There's no automatic appeal from an extradition. So that judge could have said, I'm throwing him out and I'm not allowing him to appeal, so good luck. So we had to justify an appeal application, which we did. We had 3 points to establish grounds of appeal. The most knife-edge case I think ever before that I had up to then done was Wayne O'Donoghue's verdict for murder or manslaughter. This was knife-edge to the point that this was a death sentence knife-edge. Because if Ian Bailey had been sent to France, he was going to die in France. So I've always regarded it as the only death penalty case I ever had done and hope to ever to do. We had a hearing, argument, decision, judge. Point 1, I reject it. Point 2, I reject it. And I'm going, Jesus, he's gone. Point 3, and I heard the words, and I never forget it. However. And the however was, on point 3, he has a justifiable argument to go to the Supreme Court, so I'm staying the extradition. You're allowed to go to the Supreme Court. And what actually happened was, from the time when the High Court decision to extradite was made to the point of the Supreme Court decision, sensational events occurred, which were unprecedented in Irish law up to then and to this day, involving DPP interventions, discovery of information, secret files, stuff that frightened me. We beat them out the gate in the extradition appeal. The High Court judge's decision was completely reversed. We won it on all points of appeal. There were 3. And we saved him. And that was then, and that was 2012. But they still came back in 2016, and they came back again in 2019, and they were entertained on each of them.
And how have you found the French to deal with in relation to this case? Have you a relationship with them?
No. Superior. Okay. Dismissive of our legal system. Disrespectful.
Can we move on to the High Court case? Your case was, Ian Bailey was before the High Court case. How many years ago was that?
It went for years. It was heard and concluded in 2013, 14.
But that was a bizarre decision, wasn't it? At the end, the judge found that the case wasn't properly before the court. Was that it?
No, he allowed the case to go to the jury.
Yes.
But on such restrictive grounds.
With very severe directions.
Shockingly severe, I have to say. He's retired. Best of luck to him. The restrictions were so severe. There were 62 points of legal contention throughout the 60-odd days or weeks or months or whatever it was of the trial. 62 points where the jury had to go out and retire, where legal arguments were considered. We didn't win one of the arguments.
And this is your action against Garda Síochána?
Correct. We won none of the arguments. I mean, don't get me going. We had such a case. We put out, and I was doing all this. You know, I remember watching a movie years and years ago with John Travolta. It's called A Civil Action or something. And John Travolta starts off a case, and it's the best case of all time at the beginning. He's suing some big insurance company for some cancer in the community. And as the big insurance companies start to fight him and his resources are dwindling, I think he ended up broke. I'm 10 or 15 days into Ian Bailey's cross-examination, and I'm going, oh, God, this is going to be difficult. Anyway, look, the bottom line is we put up a case that by any ordinary standard I felt was winnable. The court
but that didn't happen. And the court, in its wisdom, Frank,
in its wisdom.
Did you have a right to appeal in that relation to that matter?
We appealed it and we didn't win it because, again, we were subject to restrictive grounds. By the way, I never give out about courts. I mean, I might give out in the sense that, look, you know, whatever. If I'm in the game, I'm in the game.
Yes.
I accept. And
you're representing your client.
I respect the game.
Can I go back to your relationship with Ian Bailey? I mean, again, I go back to, you know, when we talked at the start about your general, you know, representation for clients, you know, that you kind of stand back and maintain a professional relationship. It sounds to me that you're almost buddies. Would that be fair to say?
No, it's not. Absolutely not. He's my client. I have met him in social contexts or terms or circumstances 2 or 3 times. I went to his partner's birthday some years ago back down in Glengariff. No, he's not. He's my client. I would empathise with his personal difficulties, and I would hope that I've always been, you know, properly conducted and, you know, civil and all that. But you don't become buddies with your clients.
Okay,
that's the wrong game.
Okay, and what has it been like for him?
Devastating.
You know, all these years on.
Devastating. His life is ruined by this whole thing. I did not know him before, so I can't say what he was like beforehand. I can't comment. But I know that when I met him in, you know, back in 1997, I could see damaged goods then. I saw him fundamentally damaged when he lost his libel cases in, you know, in 2003. I saw him encouraged when Marie Farrell told the truth in 2005. I saw him shattered in 2010 when he knew he was going to be thrown out to France. He was devastated. I saw him somewhat improved in 2012 when the Supreme Court saved him. I saw him encouraged when we ran the case up to 2014, devastated again when he lost, and then further devastation in the later efforts to extradite him. His life has been, to me, Kafkaesque, surreal, devastating.
Wow.
He's been ruined.
All right. And where stands the case at the moment?
It's finished.
It's finished.
Because we have kept him in the country. The civil action has gone by the wayside. Look, that's life. The only circumstance in which the matter might resurrect itself is if the French try again. My own view is that the only way in which they might attempt to try, and they're never gone away, is if they have some form of action that they might consider taking against Ireland for Ireland's non-application of what they would consider to be the provisions of the European Arrest Warrant protocol that introduced the warrant system, the framework document. If they would ever consider that, perhaps. But the Supreme Court has secured his position as a free person in Ireland, but he'll never leave the country.
Okay. Well, this has been absolutely fascinating, Frank. And after such drama and telling your story so well, can we ask him about his book? Or is that sound very undramatic? It's a bit of a come down, I think.
We can't deviate from our.
Can you find a script that is as dramatic as that? No, go on. Give us the book.
Oh, the book is going to be called "The Dog Ate My Homework."
Did you pick a book for us?
I'm going to write it. It's going to be called "The Dog Ate My Homework." I'll give you the movie if you want the movies, but the book. I mean, I've read, man. You mean essentially?
Yeah, a legal book that you'd recommend to our listeners. Or
The Trial by Franz Kafka. The way in which you can become ensnared in the legal process, and
Joseph K. Somebody must have said something about Joseph K. Is that the opening line? Something like that.
Yeah, it's many
something
years
like that. Yeah. What about a movie?
Okay, I'm going to give you 2 or 3 movies for serious criminal lawyers. Cape Fear, the second version with Robert De Niro and Nick Nolte, and it is
great.
It is the reason it's important for criminal lawyers, all criminal lawyers out there, budding lawyers, is It tells you what will happen if you mess up your client's case and don't play it by the book.
Wow. Okay. It's sort of foreboding in that movie, yeah?
For interaction with clients and getting information. It's not a criminal case movie. It is The Silence of the Lambs. And it's the important engagement between Hannibal and Clarice. And it's fantastic because Hannibal knows every answer that she's going to give. He's testing her because he wants to validate his own understanding of human nature, facts, information. That's what that's about.
I can safely say, Frank, you're the first to pick those two movies and have described them brilliantly. Mark, I would say Frank is probably the closest we've had of one of our interviewees who could be in a Hollywood movie. I mean, who's going to play you, Frank? I mean, when they do write that script, who's going to play you?
Well, I've been dealing a lot with my very good new friend, Jim Sheridan, who's a movie producer and director who did My Left Foot and all these fantastic movies. And he's a fantastic
and made a documentary on Ian Bailey.
And he made a documentary, and I've become friendly with Jim over the years. And I have great chats with Jim. But I would say that Jim would fall around the place laughing if somebody thought they were going to make a movie about me or with me in it.
Could be a Tom Cruise special. What do you think, Mark?
Anyway, another day's work.
Come here. Frank Buttimer, thank you so much for coming in and being a guest on the Fifth Court.
Thank you very, very kindly.
The Fifth Court will adjourn until next week.
So that's all from this edition of the Fifth Court. We hope you have enjoyed it. Can we say a huge thank you to our guest, solicitor Frank Buttimer, who gave us some great insights into the world of criminal defence law, Mark.
That's certainly one way of putting it.
I saw you at times holding back, but anyway, there you go. No, it was fascinating, wasn't it?
Very interesting.
Really interesting. I thought it was truly interesting. Can I say a huge thank you to him? Can I say a huge thank you to everybody in UCC for the way we have been looked after? We've done 3 interviews down here and it's been really terrific. I also want to say a thank you to our producer, Conal O'Morine, for the wonderful help he gives us, and also to the gang back in the Dublin South podcast studios for all they do for us in order to put this recording out and make it sound so good. So finally, parting comments. If there are any legal stories or any issues that you would like us to deal with, please let us know and share our podcast, Mark. Isn't that it?
That's right.
And that's it. So we just want people to share and to try and see if we can build up our listenership as always, even though we're happy enough with the way it's going.
I think we've got very good feedback so far.
Yeah, we're doing all right. We're doing all right. Okay, so from me, Peter Leonard.
And myself, Mark Tottenham.
Thank you for listening, and we'll see you soon in the Fifth Court.